Hi, good evening. Welcome, everyone. My name is Kira Parrott, and I'm the director here at Darien Library. Oh, thank you. You are too kind. And I'm so thrilled. I'm so excited to welcome you all to this evening's very special event. As many of you know, tonight is the conclusion, the capstone event in our first President series on intellectual freedom, which we launched earlier this fall. This series was the brainchild of our President of the Board of Trustees, Hutch Pegler. Thank you, Hutch. Who very smartly recognized that there were a lot of conversations happening in and around town, across the nation, but specifically here in Darien, about a variety of issues related to free expression and civil liberties and content, who has access to it and what it is and whether they should have access or not. And what was so interesting about these conversations, and sometimes arguments, is that they had been cropping up from all across the demographic spectrum, from parents and grandparents to educators to librarians to town officials and decision makers. And fascinatingly, the differing perspectives and the divisions around these issues of free speech or free expression of ideas were not easily defined along traditional political divides. It's not just a left-wing or a right-wing issue. It's much more complicated and much more nuanced than that. And that complication, that sort of friction and tension is what really interested us here at the library. Because when Darienites are talking about something, we pay attention and we listen, not only because we're first and foremost an educational institution and a place of learning, and we like to go deep on issues and provide context and texture around those issues so we can all be smarter and better understand them, but we also pride ourselves on being a place where community comes together, where neighbors meet each other, where we talk to one another, and ideally, whenever we can, learn about and learn from each other. So Hutch really had his finger on the pulse of these conversations, and he rightly said to me, we need to bring in some experts. We need to bring in some really smart people to talk about this and help us grapple and understand this better. And that is exactly what the President's Series evolved into, from lawyer and legal advocate Aaron Turr of The Fire, who was on the front lines of college campuses, to the incredible erudite and engaging Dr. Bo Breslin, the constitutional scholar from Skidmore College, to several really fascinating documentary film screenings. But when we set out to build this series, we had no idea that we'd be lucky enough to conclude it with a true legal legend and First Amendment expert. Mr. Floyd Abrams is an American Master. He is the founder of the Abrams Institute for Freedom of Expression at Yale Law School, and he has argued more cases before the Supreme Court than any other lawyer in American history. Mr. Abrams is the brains, and I would say the heart and the soul behind some of the most influential and landmark cases of the 20th and 21st century, and I'm sure that we're going to hear a little bit about some of them tonight. So we're really incredibly lucky to have him here. Mr. Abrams is going to be in conversation, interviewed by our very own Potbot, the President of the Board of Trustees, Hutch Pegler. And just a reminder that after Mr. Pegler and Mr. Abrams have concluded their discussion, we are going to be opening it up. So you should have received a little index card on your way in. So if you have a question for Mr. Abrams, please write that down. And at some point we will collect them and we will go through some of them. And thank you. And I turn it over to you, Hutch. Thank you.
Thank you, Kira. Thank you very much. And thank you to Pat Sherry and all the staff at Darien Library for all the effort in putting this series together, and particularly for tonight. Obviously, having Mr. Abrams here, I think as many of you know, I likened you, Floyd, to the Taylor Swift of the First Amendment. I don't think that there's a better, I don't know that there's a better comp, but truly, we are really, really thrilled and honored to have you here tonight. I don't think that we could have gotten a better and more appropriate speaker on this topic, and somebody who believes so passionately in the right to free expression and defending free speech rights and the First Amendment. So I'll just launch into a few questions, and we'll have a good conversation, and then we'll open it up to the audience. But
could I do one minor
please
correction at the start? This may have come off my resume. Resumes, tend to be sort of grand. But while I might have argued more First Amendment cases than anyone else, I just want to make clear I certainly have not argued more cases
Fair enough.
than anyone else.
Fair enough. Fair enough. Always the lawyer. Well, I appreciate that. But it is an astonishing number of 13 cases. And, you know, I think one of the things that we're curious about, I know the board is curious about, is, you know, some of your most memorable moments, your defining cases. We talked a little bit about the Pentagon Papers, right, in New York Times versus USA in 1971, and you argued that with a professor from Yale Law School. I wonder if you could tell us a little bit about the background and what free press precedent there was. I don't think there was a lot. Just a little bit about that.
Now, it's true that there hadn't been many free press cases in our history. There were cases from the 20s or in the middle of World War I, right before the 1920s, which people were jailed for handing out pamphlets against the war and urging people not to register for the draft, and a lot of people went to jail, in fact, in those days. But the Pentagon Papers case arose during the worst of the war in Vietnam, when things were really going badly. There never seemed to be a way out of the war, no way to win it, and unwilling to lose it, and I mean, a terrible situation. Suppose, you know, we could have won it by using, you know, weapons of such magnitude that the world would never forgive us for doing it. But in terms of what was available then and the like, it just dragged on and on. And American presidents, each in turn, even starting at the very beginning, one could say, even during World War II, the French then owned Indochina. The Japanese conquered it. And, you know, there was of minor but genuine interest to decision makers in Washington. But as time passed and that war was over and we were in an ongoing, and to some great extent we still are, but ongoing conflict with communist powers in the world, mostly the Soviet Union then. The war that started with the French fighting against local, sometimes communist, sometimes not people, was going worse and worse, and the U.S. gave aid and then wound up sending many soldiers. It became an American war. It was an unpopular war. There were drafts then, so a lot of all men then were drafted from after high school or into college, and it wasn't going well. And any president that touched it was losing out. So Lyndon Johnson was president. Robert McNamara was the head of he was the Secretary of Defense. And McNamara got an idea that, well, why doesn't somebody write for me a serious, nonpartisan, and no excuse, just a real description. How did we get into this? And that was during a time of enormous fighting in the war. I used to remember the exact time, but you know, one American soldier dying every blank days, and even worse than that. So an unpopular war that we couldn't seem to end We couldn't seem to work out a deal. So McNamara had these papers, which would later become called the Pentagon Papers, put together, all classified, top secret. Top secret is, at least in theory, the highest level of secrecy, the revelation of which would do grievous, or at least great harm to national security. That said, a lot of papers then and now are over-classified, so just a word of warning. And the other part of the deal is that if any document is classified top secret as part of a bigger document, the whole document gets classified as top secret, and that is still true today. So this document was prepared, and there was growing opposition, sometimes angry opposition, sometimes people who started out for the war. Daniel Ellsberg was a Marine, very well educated, who rather quickly became disillusioned about the war. He was very high up. I mean, he was not just a fighting Marine to call it, but his background had been such that he worked in the Defense Department before the war, and he became one of the authors of the Pentagon Papers, one of the authors of the history of how we got into Vietnam, going back to World War II, through President Eisenhower, through one president after another. Ellsberg became disillusioned with the war and more angry at the war that was going on. He was in Vietnam and angry. And he made available to the New York Times these documents, the Pentagon Papers, the, I think, 2,000 or 3,000 pages of the Pentagon Papers. Stories like this, if this were a journalistic community, or if you were all journalists, I mean, I would go through with you how many different versions there are of who got the papers first, how it got here and there. Did the journalist deceive Ellsberg, et cetera, et cetera. In any event, Ellsberg wanted it to get out. He called the Times. The Times had a reporter who was there for months with him. And the reporter apparently surreptitiously, and in Ellsberg's absence, printed them out on what I'll call Xerox machines. So one page after another, after another. And the New York Times, in June of 1971, started publishing portions of the papers. They themselves had former CIA people, former State Department people. They called in to make sure that they were not releasing information which could be harmful to the country, but nonetheless, these were top secret documents. It is a criminal offense. It would have been a serious criminal offense for Ellsberg to have turned them over, and it was arguable whether it might be criminal or might not for the Times to do so. Anyway, the Times started publishing. I, at that point, was a pretty young partner in my law firm, the Cahill Gordon firm in New York. And I was doing a good deal of First Amendment work for NBC then, first as an associate and then as a partner. The Times started publishing, and I got a call from the general counsel of the New York Times, who I had met but didn't know. saying, the government is saying they're going to court. The government is saying if we keep publishing, we, the Times, will be violating the Espionage Act. And we have retained Professor Alex Bickel at the Yale Law School to represent us. And he and we would like you to work with him on this case. That's how life changes. And so the case was in court, and 15 days later, the U.S. Supreme Court decided in favor of the New York Times in a series of opinions. You can only imagine, remember, 15 days for lawyers is, you know, halfway to New Haven. I mean,
well played.
And, you know, and so there was a district court argument by Professor Bickel and a partner of mine, much older than I, cross-examining government witnesses. The Times won in a very eloquent opinion of a brand new trial judge, a judge just appointed by President Nixon, who was in power then. I mean, now so many things are recorded even as of then that people aren't thinking could be used against them or revealing things they might not want. So we have the tapes of President Nixon being told by the Attorney General, John Mitchell, who the judge was who would be hearing the case in his first, literally, it was his first day as a judge.
Wow.
And this case comes in on his desk. And President Mitchell said, and he's grateful. So we went to court, and I argued one or two significant motions. Bickel was the lead counsel. And we wound up in the Supreme Court, let's say 12 days later, and 3 days after that, the Supreme Court decided that there could not be a prior restraint, a limitation by the courts on what the Times could print. Now, they left open, without quite saying it, but for lawyers, we understood, they left open the possibility that the Times could still be indicted if the government decided they had violated the Espionage Act. But the principle that it is extremely difficult, extremely unlikely, very difficult for the government to get a restraint, a ban on what the press can print, was so strong that even in the middle of this war, and even with the government saying there would be great harm as a result of publication, it turned out not to be true, as we argued then, but who knew is the truth. Yeah. You know, in 15 days, the decision came down in our favor. I would say the key moment in the case, certainly the most memorable to me, is when Justice Potter Stewart, not so well known yet on the court as an active supporter of the First Amendment, which he was and became through the years, asked Professor Bickel this question. Suppose when we go back to our chambers and we read the Pentagon Papers, and we conclude that there is a good chance that some young man who had a high draft number will die as a result of publication of these papers. Are you telling me, he said, are you saying that in that case we cannot prevent the Times from publishing? It was a question that we had, Bickel and I, gone over a lot in advance. The tone of it seemed more hostile than we later realized it was, but judges sometimes ask really hard questions when they're on your side to try to persuade the other judges of that. So Bickle's answer was essentially, and this was, by the way, his first argument anywhere. He's a professor. What do they know? So, and the answer was something like, if that were the situation, my dedication to the First Amendment would clash with my devotion to human life. And Stuart getting irritated with, thanks a lot for your conflicting views. What's the answer? And the answer was, in that case, yes, that there could be a prior restraint on publication, but you won't find it. I mean, nothing that bad is in the Pentagon Papers. So in any event, that was, I thought, the key moment. And a few days later, the court came down in our favor. And if I can just indulge myself a moment more, 3 years before, I had been in India, and I was with a classmate of mine from Yale, an Indian woman, a princess, no less, who had said to me, "Would you like to go to my fortune teller?" She said, she was Mrs. Gandhi, then the Prime Minister. Her fortune teller, she was so-and-so. I'd never been to a fortune teller. Sure.
Sign me up.
Yeah. So we went to her fortune teller, a man on a stage, like of a movie theater, a beaten-up movie theater. They spoke Hindi to each other. She translated for me, and she would ask me, he had questions. What date were you born on? Okay. What time were you born? Questions like that, and really, but not many. And then he started talking and talking, and she's listening and listening. And he finished and said, I said, well, what did he say? He said, you will go to your nation's capital. I remember those words because I was sure he didn't know it was Washington. You will go to your nation's capital and do something that will make you really, really well known.
Wow.
I forgot that.
Wow.
I had an older sister to whom I told that story. She remembered it. And when the Pentagon Papers occurred, she said, you remember that fortune teller?
We should all sign up.
So,
Wow. What a great story. Yeah.
sorry to take so long.
No, that's incredible. And it's I think I read I think in one of your books that, and we take for granted, I think, a lot of the freedoms that the press enjoy for a lot of the cases that you've argued, right? Because again, that precedent didn't exist, and it could have been disastrous if the cases had gone the other way. You mentioned the question, answering the question to the justice about having conflict between the First Amendment and otherwise, bad outcome. One of the questions I'm very curious about is you've argued a lot of very high profile, obviously high profile, but controversial cases that have, frankly, enraged over your many years, both the political left and the political right. You think of the Brooklyn Museum of Art, during that exhibition, and all of the threats to defund that and noise from the then Giuliani administration in New York. But then subsequently, you know, you defended Mitch McConnell, or you worked with Mitch McConnell on Citizens United on that brief, which was a case that, you know, obviously the generally speaking, the left was not very happy about. So it is interesting to me, and I think it remarkable, you know, that you know, just by being consistent in your principles, and I don't want to say absolutist, or maybe that's your view, I don't know, but your principles around the importance of free speech and the First Amendment, how that affected you, whether you had external pressures, and looking back on it, would you have done anything differently based on any of those things, just in terms of, again, being on the, quote, both sides of those cases?
No, I was sort of, let me say that when I was asked by Senator McConnell to represent him in that case, I'm not on his side in general and politically. It certainly did, and I wasn't sure what side I was on with respect to campaign finance issues, just because I hadn't thought about them a lot, and I thought about them, and I did agree with the side I wound up arguing for. But yeah, I mean, that you can't play the, I mean, lawyers have different clients at different times, and I don't criticize lawyers for taking this case and that case, you know, not just unpopular, but some case I really hope the lawyer loses, or I think it's bad for the country if the lawyer wins, you know. But I don't blame the lawyer for taking the case, so that, I mean, that, I've been fortunate, I think, in that I haven't had in the First Amendment area a lot of hard decisions to make about whether, for one reason or another, I shouldn't, I don't want to represent this client or not. I've had some where I was new enough to an area, like artificial intelligence, which I'm still new to. Yeah. Where, yes, I represented, not in the Supreme Court, but in the lower courts, an entity which has, well, now, 50 billion photographs, so to speak, of people. I mean, they take photographs from places where they are public, you know, public places like the public internet. They get most of what they have from the internet, and they can transform it in a technical way so it's not on a piece of paper anymore. You know, it is all there. You can see this is not my area. No. You know, it's all there and available. And Illinois has a law, only Illinois has a law, saying, in effect, you need consent to use pictures of people. Now, in some cases, the Illinois courts themselves have said that's unconstitutional. For example, taking a picture of someone on a beach who you don't know without consent. That was when the Kodak camera first came on the scene in 1898. Wow. That was what led the words Kodak fiends to come into being, because people in rather nice areas were deeply offended, angry at the idea that without consent, and it was often couched in terms of protecting women in those days, you're taking a picture of a woman in a bathing suit without her consent. And that was a big deal. I mean, there were never laws against it, but there was a great deal of anger at that time And you know, by the time I was representing this then new company, you know, everyone's used to beach photos, you know, but the idea of what anything, high school photos,
Sure.
Are available. I mean, you had one judge really angry. My child, you're going to take a picture off a junior high school or kindergarten yearbook just because it's public, and you're taking it. It wasn't an easy case. In fact, the client could at some point no longer afford us. So it
That's a strategy.
Never came to fruition.
Yeah.
While I was there, but it's a good example, I think, of how changing technology leads to a situation where there's a First Amendment issue. There certainly is a serious First Amendment issue there, but should the First Amendment carry the day in a situation like that? I mean, we have similar issues about pictures being taken from entities flying in the sky. Technology gets better all the time. And people walking down the street can be photographed.
Yeah.
So in any event, that was, I think of that as a good example of how the changing in technology leads to new First Amendment challenges.
Yep.
And also a good example where, you know, the First Amendment maybe shouldn't carry the day, but whether it should or shouldn't, one thing we know is that as technology gets even better, it will be very difficult to retain the current equivalent of privacy.
Privacy, yeah.
Let me just one example. This company was under a lot of fire, my client, and in part because they were sympathetic to the cause, in part because they thought it was good for them, they volunteered for free to help the battle against the Russians in the invasion of
Ukraine.
Of the Ukraine.
Yep.
Sorry. And what did they do? There are pictures of Russian high school kids too. When there was a dead Russian soldier, they would take a picture, so to speak, and they're good enough, the technology's there, so they could identify the soldier without a name or anything from high school pictures.
Wow.
And they aided the Ukrainian side by making that available to them, and the Ukrainian side wrote letters to Russian mothers, letting them know that their son had died, because the Russians don't tell, you know, anything like we do, as a way of trying to get them to oppose the war. But that's just an example. As times change, the issues, I don't want to say they're the same, but there is a conflict, an inherent conflict between the right to know and even the right to speak and other important social interests.
So on that point, it's it's adjacent. It's not necessarily where civil liberties and privacy might conflict with the First Amendment, but in social media, right? Particularly in an election year, there's a flood of litigation where the Facebooks, the TikToks, Twitter X whatever is, they're in many cases they're defendants. I think in some cases they're in certain states they're plaintiffs. And where in that case, from technology perspective, where do you draw the line between, quote, disinformation, right, and censorship, and what does that mean for, I think both sides love this expression, right, for protecting democracy in an election year. Curious your thoughts on that.
Yeah, well, first that issue, those sorts of issues, are before the Supreme Court now. That hasn't been argued yet. What's before the court are statutes from Florida and Texas, which basically, I'm going to, for our purposes now, assume good faith. I mean, there's always politics, but I'll assume good faith on the part of the...
Safe assumption.
That statutes basically saying that either consent is needed or you have to be fair in what you carry and what you don't carry. That if your policy is not to carry such and such a view or position, and let's say it would be constitutionally protected if the government said you can't print that. But it's Nazi speech. It's pornographic speech, which are the two types of speeches. I can tell you that the owners, so to speak, of the social media are most concerned about is that this sort of speech is protected in general by the First Amendment. And enough people don't want to see it or have other people see it that advertisers won't subscribe to be a part of an entity that shows that sort of speech. Those are the examples that are, in my view, the best that the proprietors, the owners of these entities have cited. What have the other side cited? Here's a question that was asked in the Court of Appeals argument in the Texas case. Are you saying that a social media entity could have no Republicans on, only Democrats? Now, the answer to that has to be yes, from a social media perspective. They can say we won't do it. You don't think we would do it, that people would be angry, no, blah, blah, blah. But an honest answer to that question is, and the answer given by counsel and that question was yes. A newspaper can do it. A magazine can do it. Why should we be different, or put in the way they would say, why does the First Amendment not protect us when we decide what to carry and what not? And the Department of Justice, that case is now in front of the Supreme Court. The Florida and Texas both have adopted statutes basically promulgated from political figures from the right objecting to what they view as bias towards the left or towards the Democrats. And they've passed laws basically saying you have to be more First Amendment-y than that. You've got to carry more. If you carry this, you have to carry that. Now, that would clearly be unconstitutional as applied to any newspaper. You can't tell a newspaper what to print as a really fair, overbroad, but very fair statement. And so the social media entities in an argument that's going to occur in the next few weeks, are saying we're entitled to freedom of the press, and so we should be able to decide. Now, they will also say, I mean, of course, we're not going to do that. Everyone will be angry at us, but an honest answer to, are you really saying that's what you could do, is the answer that the lawyer gave in Texas. So in Florida, the statute was held unconstitutional as a violation of freedom of the press. In Texas, in federal courts, it was held constitutional. And so that's what the Supreme Court does. I mean, more that than anything else. When there are conflicting rulings on the Constitution in the lower courts, they answer the question, what does the First Amendment mean in this context? And there's one additional fact that I think is really interesting and will certainly be argued by the losing side below. And that is that when the internet began, Congress passed a law called Section 230 of the Communications Decency Act, which is basically saying these new entities, what became the internet, are not responsible. You can't sue them for, my libel of you online. Because they can't check. Facebook, the last time I knew, had 2 billion subscribers around the world. So the fact, though, that Congress has been so, has treated the internet so much more protectively than is true with respect to the print press. I mean, the New York Times is responsible, can be held guilty for libel if they print something saying, this person killed that person, and it's not true. They can lose a libel case. The social media entities are saying truthfully, more or less truthfully, I think, sort of, what do you want from us? You really, we have to, every time there's a communication or a false statement, we're supposed to know? So that case is a really important case, really important because the internet now is so important, and social media is more and more the place. I'm sorry about it, and my journalistic clients and friends are surely sorry about it, but that's the place where people get news now.
Indeed. Yeah, absolutely. I'm changing gears a little bit, but I'm curious, over the years, the different justices you've argued in front of. I think we were chatting, and I think you'd previously compared arguing a case in front of the Supreme Court like a batter, being in the batter's box facing 9 potential opponents or 9 opponents, and I'm just curious if there are any particular justices that surprised you, if there were any that were intimidating or hostile or even amiable. I mean, this is a little bit different than a legal question, but I'm just curious about that.
Remember, as I answered, that sometimes questions are asked by a justice that is sympathetic to your side, but asked in a way where they hope that your answer will be good enough to persuade one of their colleagues who is not necessarily on your side. I would say that Justice Ginsburg was angry at me in the Citizens United case. She felt very strongly about the case. I knew her. Therefore, I think she was disappointed in me and I don't want to say angry. She didn't care that much about me, but you know, that I was the face of what she was so sure was the wrong side, and in her view, the regressive side. But sometimes you get a member of the court that's, I mean, well, why not? Mean. That you know is upset at your position or at your presumption. If you somehow sound, you know, off base, as if you know more than they do, as if you're teaching them something, things like that. I had an argument in which Justice White was a very tough guy, former, you know, all-pro football player, a buddy of JFK in that world, and was arguing a case. And he asked me a question I hadn't thought of. Now, one of the things, really, if you're any good at all, that's your job. I mean, that's job description, to figure out what's the worst they can ask. I mean, what's the weakest argument I have, or to put it the other way, the best argument the other side has, and what's the best answer to it. You know, and you won't always win because, you know, you don't choose your side in that sort of way. But he asked me a question. I had a case involving, I don't even really remember the case too well now. He had that effect on me, where he asked a question I just hadn't thought of, And you know, this is all on your feet, and again, that's the job. That's what it is. If you haven't thought of it, you know, it's your fault, whatever that means. You were supposed to have. That's you know, you can't know it all the time, but you're supposed to. And he asked me a question. Again, I forgot the case. I'll simply say, the question was something like, suppose this were in a grand jury instead of a regular jury. And it just hadn't occurred to me. And I took an extra half second, which feels like half an hour of silence. And he said, well, would it make any difference? And I remember my answer. I think it's the worst answer I ever gave. I said, I hope so. And you know, trying to be charming. Well, he was having none of that.
He wasn't amused.
His answer was, you hope so? So I haven't recovered. That's only 35 years ago.
Wow. Wow, that's incredible. So talk to us a little bit about your current project. I think you're working on a project around the press clause of the First Amendment up at your institute in Yale. Curious about that. I know you feel very strongly about, you know, certainly the press having protections, as in, you know, the New York Times or ABC, NBC, CBS, you know, the networks having protections, but also, you know, journalists and reporters having protections as well. Just curious if you could tell us a little bit about what you're doing now.
You know, the First Amendment deals with a number of different subjects. Starts with freedom of religion, is the beginning of it. And it moves then quickly to Congress shall make no law abridging the freedom of speech or of the press. That's all it says about this, just those 40 words. We count the words. And the question of what "or of the press" means requires, first of all, one to be clear, and the law is not, about what is the press. The press is the only industry, so to speak, in the Constitution that is not the government. The only privately owned entity that is not part of, the Congress, the states, the this, the that. And the press clause has not meant a lot in our history, most of all because we do provide very broad protection for freedom of speech. And the press certainly engages in speech. So in a lot of cases, you don't need a separate reference to the press to address the question of whether what Congress is doing here or there, or some state does, is allowable under the Bill of Rights. The Bill of Rights, I should say, since the Civil War, applied to the states too. So even though it says Congress shall make no law, after the amendments post-Civil War, that became Congress or the states. And the states, meaning the cities, policemen, the government. So it has seemed to me for some time that it's surprising and sometimes sort of limiting that there are so few cases and so few, therefore, descriptions of what we mean by "or of the press" in the First Amendment. What's protected? Confidential sources of journalists. I tried to persuade the Supreme Court once and did not succeed to change a prior opinion of it, which seemed to say no First Amendment protection for journalists' sources. Journalists still claim that protection, I should say, and many states, I don't know in Connecticut, but in New York, we have a statute that provides a lot of protection for the press. But the question of what the press is, for example, social media.
Right.
That's the most important issue. I mean, the case that the social media entities will be relying on most in their argument against the states saying you can't do this, you can't do that, is a case which arose in Florida, in which Florida passed a statute saying if a newspaper criticizes a person who is running for office, they have to give them a chance to answer. They have to allow a response to what they say, at least if it's criticism, that they have to allow an answer. A professor, really, with a law review article, had urged that there ought to be more statutes like that in the interest of fairness, in the interest of giving the public more information and the like. From the press perspective, that would not only change on a practical level what they say, because if we always have to print an answer to everything someone says or that we say, we're going to have to give space to other things which we may not think are newsworthy, or even with which we disagree, and we think it's wrong. And the Supreme Court wrote an opinion, 9-0, saying editing is for editors. That's a quote. The press decides what to print. You can't tell them that they have to print this or that. And yeah, sometimes they'll be unfair. Hopefully there'll be competing views of other news. Again, that was early 70s already, still only newspapers and a brand new television entry, you know. So that opinion, which was really loud, firm about, and as if it's the most obvious answer in the world, they write that way sometimes, was saying, what don't you get? Who could imagine? Some state legislature telling a newspaper what to print? All right, so that case, you know, and the way life works is that the Supreme Court writes that in this case, and then it becomes binding precedent for other cases, and you know, the law very broadly in this area of required speech. If you say that, you have to let blank happen. You have to allow the answer. But what about social media? Social media already favored, as I said, by Congress with this section of law, which is so protective of them. Yeah, basically, they can't be sued for libel for what you say on social media about someone else. If the New York Times published that, and what you said was defamatory, they're responsible. But on social media, that's not true. And that's not the First Amendment speaking. That was Congress at the very beginning of social media being persuaded the only way this thing is going to work, and it's such a great idea. I mean, from a First Amendment perspective, too.
Sure.
That, more people speaking, not just freely, but communicating to the world. You don't have to own a newspaper anymore. You can go online. I mean, what could be more First Amendment-y than that? But, you know, now come these state statutes, and a moment came in that Texas case where a very conservative jurist asked the lawyer, are you saying that your client, Facebook or something, one of those, could only allow Democrats on? The answer had to be yes. The Miami Herald would have, you know, people would argue we wouldn't do it, things like that. But one of the rules of the game in the Supreme Court is that you really can't avoid a question. You can try, but it doesn't get you anywhere to answer a question like that by saying we wouldn't do it. You could answer by saying it wouldn't happen. I mean, you ought not to go down the road of saying if we carry A, we have to carry B, because the effect of that is that we really won't carry A. I mean, it's going to be lost. We're going to have less speech, period.
Okay. Do we have a couple questions from the audience? We got cards here. Who inspired you to study law, or what experience did you have that set you on this journey?
I didn't know what I wanted to do. I went to public school in Queens, where I grew up, high school there. People went to college. That was the next thing. What one could do without thinking or having some great idea about what to do with your life. I did enjoy and did find really interesting press subjects, but maybe this is interesting. I was sort of on the other side. the national debating topic. Any of you that participated in debates in high school or college, I think both, there was a national debating topic every year. And this one, when I was around, was called Trial by Newspaper. And it was basically, shouldn't we be fairer to defendants by not letting newspapers publish inadmissible evidence? In England, that's illegal. In England, a journalist would go to jail for doing just that. And Canada, I mean, great democratic countries, in the service of having a fair trial. Here, we wouldn't have had the revelations about Watergate or the revelations about all sorts of things which wind up in court, as most things do in America, if newspapers weren't allowed to publish whatever they found out that they thought was so. But that's not the law in other great democratic countries. Well, I was persuaded when I first heard about that the English sounded right to me. It's not fair. And it really took for me until I was out of law school. My first job was at Princeton University, where I worked for a professor who was doing a book on the Supreme Court. And in law school and thereafter, in that year and a half or so, yeah, I became more and more taken with and ultimately persuaded by the justices on the Supreme Court, who were the ones who were defending in an extraordinary way, beyond England and Canada, the First Amendment that we have. So it took a while, but I really did find interesting. I mean, the first great Supreme Court cases on the First Amendment were in World War I, in which radical groups were basically handing out leaflets saying, "Don't register for the draft. Oppose the war. It's a wrong war. We shouldn't be in World War I." They went to jail for saying that. And cases arose in the Supreme Court. And some of the greatest First Amendment opinions ever, written by Justice Brandeis and Justice Holmes, basically said that that was free speech. There were things you couldn't say, secrets, national secrets. But you're opposed to the war, you're allowed to say it. You don't think people should be drafted, you're allowed to say it. Are you allowed to say, don't register for the draft? No, it gets harder each step you go. But basically, the position that these really great jurists who could write like a dream were articulating was a very protective one about free speech and at least implicitly freedom of the press.
Next question, sort of a couple-parter, but a couple questions around the current makeup of the Supreme Court and how specifically the fairness doctrine or the Pentagon Papers might be ruled today, and what your thoughts are on the current makeup. And I have another question, which is a little bit of a follow-up relative to the modern Supreme Court. You know, there is some talk, a fair amount of talk, I guess, in Congress about potentially adding justices to the Supreme Court. So I'm just curious at sort of today's view on those cases and your view on sort of talk in the legislative branch.
Yeah, let me address that first. I'm not in favor of adding people on the court. Congress has the power to do it under the Constitution. I mean, there's no serious argument that Congress may not expand the amount of people. It wasn't 9 for a number of years.
Right.
Whatever disagreement I have with the court, or whatever disagreement others have with the court, I think it would be a mistake. It would politicize the court. We already have that problem, but it would politicize the court even more and much more, and would therefore have the effect of limiting public acceptance of the law as articulated by the court. I mean, it's one thing to disagree with the court. I disagree with a lot of its gun, Second Amendment opinions, for example. But, you know, that's what they say, therefore that's the law. You start to lose that, and you can lose it badly, that is to say, broadly, if you start adding justices because you're unhappy with where this court comes out on this subject or that subject. I'm sorry,
Yeah, well, how would, in your view, how would today's court rule on the fairness doctrine or the Pentagon Papers or?
Right. The fairness doctrine was really ended by President Reagan, by certain acts on his part, which he had the power to do. Fairness doctrine, it was never in a statute, so it was always what the Federal Communications Commission had come up with. So that's not something where you need a statute. You need the FCC itself to say we're not going to do that anymore. The fairness doctrine, I'll just say briefly, did seem to me to be antithetical to the First Amendment. Because basically saying, if you put this guy on, you've got to put that guy on. And I saw a lot of that when I was really a starting lawyer. My firm represented NBC. And you'd wind up in situations. I remember there was a big to-do in the country about building what was called the Alaska Pipeline. Really enormous conflict about whether it was a good idea or not. NBC asked some congressman, without thinking about it, you know, I mean, a serious person, and the congressman was against the pipeline and said so. And then the lawyers came in from NBC and said, well, you got to find someone for the pipeline now. Right? Now, because they're journalists and don't want to be viewed as not journalists, they can't go around and sort of just ask, what side do you want? Because we want. So they got some really famous person, and they sort of teased an answer out. You know, what do you think of this? What do you think of that? When all they were interested in is, could they put him forward? And so they put him on, and of course he said the wrong thing. So now they had two people on one side. And they finally put a panel together where they could be sure, you know, that the leader of the anti or pro pipeline side. A real problem with the fairness doctrine was that political leaders, particularly President Nixon, but President Kennedy as well, tried to use it in a way to benefit their side of things by putting pressure on the FCC, remember, which is not elected, and people want to stay as commissioners or to be reappointed as commissioners. So there was that. I don't have a strong view on how they'd come out on the Pentagon Papers, because I think that was so unique factually. It's not supposed to matter, but it does. That was a really unpopular war, and that half the country, at least, wanted to end, find some way to end it. Bring the boys home. It's not worth. And we had generals in Vietnam. Everybody was lying about it. Every administration was providing information. That was one of the things that the Pentagon Papers was important about. It showed the degree to which the public had been lied to, that when the public was told one thing by administrations, here you see that this Secretary of Defense just wanted to get out with honor, find some way, with perfectly understandable position, but the effect of it is that he lied a lot. Things are going well, things are getting better, therefore you can take them, So it's hard to extrapolate for me, therefore, from the Pentagon Papers. I do think that the court is a strong First Amendment court, that the court would require, one can make up hypotheticals, but would require an extraordinary situation for them to approve a prior restraint, a limitation, a bar on what a newspaper or broadcaster could say about one thing or another. And that cuts across party lines and ideological lines on the court. I would say the court, in general, this court, is quite protective of the First Amendment. Sometimes conservatives are more protective, sometimes the liberals are more protective, but really taken as a whole, this is a very, not just pro, but a court that is, in effect, willing to pay the price of the harm that some speech can do. Speech can be dangerous. Speech can lead to bad, wrong decisions. It can lead to wars, to make up your own hypothetical. But the basic proposition, maybe the clearest proposition of all under the First Amendment, is a restraint, a government bar on what can be said is just about always unconstitutional. The only thing that almost approaches that is truth-telling can't be barred, even if the truth does harm. Libel suits can only be brought or won about false statements. You can't bring you really hurt my feelings, and you didn't have to, and the harm is enormous to me that you said that in America. And again, that's more unique here than it is elsewhere in democratic countries. So on the First Amendment side, I think this is a good court, and some of the most controversial decisions, like Citizens United, whatever you think of the result in Citizens United, at least the impact is likely to be a strengthening of the First Amendment protections against actions by the government, often in good faith, actions by the government which require a limitation on speech.
Well, thank you again for making the trip up here. Thank you, everybody, for coming. Really, really informative, great session. Thank you.